absents himself. Okay, so it looks as if everyone can certainly hear me, am I right?
Yes.
Everyone give me a cheery wave if they can hear me. Oh, good. That's I worked out how you do that. Now, good. I've got next on my agenda was address any technical problems. So that's good. So as you know, I'm Frances McCleary and I've been appointed by the ministers to hold a public inquiry into the objections made and not withdrawn into the Perth and Kinross Council Transport Futures Project Phase 2 Cross Tay Link Road Compulsory Purchase Order 2019 made by Perth and Kinross Council using the powers conferred on them by the Roads Scotland Act 1984. My task is to prepare a report for ministers with my recommendations as to whether the order should be confirmed as promoted or otherwise. Now, this is a pre-inquiry meeting intended to discuss certain matters in order to facilitate the process of my inquiry. Being in Glasgow, my broadband's usually fine, but reporters usually find these meetings work best if all the participants who are not speaking would mute their microphones and switch their video off. So can I ask everybody other than Ms Maguire and Ms MacLeod to do that? Mute and switch your video off. It's also a little more helpful for me because I need only look at two people. That's interesting. The arrangement of screen isn't ideal. At some point we can maybe talk about that, but I think I can see them. Now, I'm assuming that between you, particularly with yourself, Ms Maguire, I think you're the one with the arrangements for internal communications. But if either of you need to take instructions or anything, you know, and you need a short recess for that, just say, and we'll see if we can facilitate that. You can't exactly be your ear can't be whispered into in these proceedings. If it all goes pear-shaped, you'll know to contact Callum in the office by phone and he'll see what he can do. This is actually my first. Oh, Ms Maguire's already disappeared. I hope that's diagnostic.
I can still, oh no, I can still see her, although she may be frozen at the moment.
You see, I should not have been so complacent. Ms. I can't tell whether she can hear me, you see that. Right, so I've got a little warning triangle in the corner. Oh, there you go. Now, were you able to hear, or did you lose sound?
Hear both of you.
Right, you seem to be buffering, but it's the difficulty of you alerting me that you can't hear me. Right, okay. We'll see.
Hear both of you.
Right, it's you we can't hear. No, well, we'll see. We'll maybe see if we can address that. Now, as I was saying, this is my first time, so I'm feeling my way a bit. So bear with me. These proceedings, as I think you're aware, are being webcast on the DPA feed, and the meetings being filmed for live and subsequent broadcast. I think you've had some I think Callum has alerted you to the usual basis at which we proceed with that, and as I understand you, nobody's got any problems with that. But for the wider consumption, the DPA is a data controller under the Data Protection Act 1998, and data collected during this webcast will be retained in accordance with the Scottish Government's published policy, including but not limited to, for the purposes of keeping historical records and making those records available via the DPA's website. In participating, you're consenting to being filmed and to the use and storage of those images and sound recordings and any information pertaining to you contained in them for webcasting and training purposes, and for the purpose of keeping historical records and making those records available to the public. Has anybody got any questions about that? No. Ms Maguire, are you there? I thought that was quite a good bit of official prose that would let us see whether the problems we've obviously got with Ms Maguire can be resolved. Callum, can you assist at all with the fact that Ms Maguire has disappeared?
I think she's just dropped out now. It seemed that she was having bandwidth issues just prior to that. When she joins back, if you could advise that she turns her video off, that should help with any internet
Help
connection.
her.
Yeah, that should help her. You won't be able to see her, but it should help with the audio.
Hello, I'm sorry, I seem to have vanished for a period there.
You did. How did you, were you able to hear what I said? It was all that stuff about data protection.
I heard
hear
the
that?
data protection content, yes.
Right. Did you catch Callum suggesting that you switch your video off because that might assist?
Okay, I'll do that just now.
It means that you'll have to shout if you because you won't be able to attract my attention otherwise.
Okay.
Can I double check that you can hear me?
I can hear you, yes.
Good stuff. Right. Okay, well, we'll see how we go. Now, moving on, does everybody have a copy of the agenda? Oh, I like that, Mr. McLeod.
Yes.
I'll immediately have to get on of it.
I think it may work. I was just going to say, Mal, I think it may also work for Miss Maguire if her camera's off, so she can use the emojis to, raise her hand or give a thumbs up or whatever. Yeah, there we go.
Well, there you go. What a learning curve this is proving to be. Right. Okay. So, again, for the purposes of the tape, can I move on to the second part of my agenda? I hope you've got the agenda. All right, you do have. That was the thumb. Can I start with Perth and Kinross? So, Miss Maguire, could you just sort of read yourself into the record, as it were?
Yes, I'm here on behalf of Perth and Kinross Council this morning, Jackie Maguire from Brodie's. I'm joined by some colleagues this morning, Miss Gillian Ferguson, who's the Roads and Infrastructure Manager at Perth and Kinross Council and the Project Manager for the Cross Tay Link Road project, Debbie Robertson, who's a solicitor with Perth and Kinross Council, and Denise Ritchie, who's a Technical Manager with SWECO, who are the technical advisors to the Council on the project.
Okay. Okay, thank you. Mr. McLeod, if you'd read yourself in.
Certainly. Ewan McLeod, Shepherd and Wedderburn, and I'm representing Robin Filshay and A&J Stephen, who are the objectors to the compulsory purchase order.
And that's a joint representation, is it, Mr. McLeod?
It is,
right.
Yeah.
Okay. Now, can I just check, is that there's nobody else on the line, I assume, that who wishes to participate in this morning's meeting? Good stuff.
Not from my side, no.
Fine. Okay, now we'll move on to agenda item 3, my introductory remarks. So I convened this pre-inquiry meeting in order to discuss with the participants who are still really involved from the point of view of the objection that's not been withdrawn, to discuss and plan the public inquiry and to discuss with you how that could most effectively be done. Of course, none of the merits of the order or the objection will be investigated today. The outcome I'm hoping for is broad agreement on a plan of action and some ideas on suitable timescales. After the meeting, I'll be issuing a note of the meeting, which will also include my procedural directions. The things I'm hoping we'll settle today, as much as we can, will include looking at the matters which will be relevant to my investigation and report and those that won't be relevant, the best form of procedure for considering the matters to be investigated within the ambit of the public inquiry, such as inquiry sessions, hearing procedure or written submissions procedure, to exchange ideas at least about the arrangements for the publication of documents, particularly the promoters' documents, to fix the dates for any oral sessions and at least consider possible arrangements and timescales for the wanted exchange of documents, any hearing statements or written submissions, and how to tackle the vexed question these days of site visits with regard to the safeguards and the restrictions that we currently have. Now, I mentioned that my note of this meeting and the procedural directions. Once I know more about what the public inquiry is going to be like after this meeting, I'll also reflect further on what order materials I need to see for the purposes of my report. and what additional materials by way of further reports or background documents might be useful to me, and I possibly give some guidance or directions, particularly to the Council, about what I consider I might need. I might not need everything that's on your 2 document inventories, for example, or I might request some additional subject-based reports. But apart from mentioning that to you, I want that I think will emerge as I get deeper into the content. So I don't expect actually to be talking very much about documents today, except sort of general ideas about how we could do this effectively and usefully. So moving on to my item B under this agenda, which is the scope of the investigations. Now, both the participants are represented by seasoned professionals, so I'm not going to spend too much time going over the basic principles behind CPO inquiries, which will be well known to you, but just to flag up what I think are the main principles we should be bearing in mind as we go forward this morning. First, my function is investigatory. The outcome of the report should be a clear and comprehensive report which equips ministers with all the information they need to decide whether the order's in the public interest and should be confirmed, or whether there should be any other outcome. Secondly, my inquiry and my report must be into the whole order, not just the objection. And it always lies with the promoting authority to demonstrate that the whole order should be confirmed in the public interest. And in a related point to that, even if it should be that the objection, which is the only one left now, is withdrawn, I will still require to make a report on the order to ministers. That arises from the Acquisition of Land Authorisation Procedure, Scotland Act 1947, first schedule, in which paragraph 4.1 provides that if all objections are withdrawn, ministers, on being satisfied that the proper notices have been published and served, may, if they think fit, confirm the order with or without modifications. Nextly, the level of compensation is not within the scope of matters to be considered, because that's for the Land Tribunal. My view on this is that extends to the consideration of negotiations between the parties or any dispute about accommodation works. It's often the practice of councils to make a reporter aware of what's going on, but that's usually by way of background knowledge rather than in any situation that would allow a reporter to have regard to matters of compensation, or for that matter, negotiated accommodation works or negotiations. That's not to say that the impact of the scheme as proposed on an objector, including economic impact, might come into play as a relevant matter, as long as that keeps clear of trying to make any determination about what compensation might be. Nextly, I am legally qualified, or I was once, a bit retired now, but I am not appointed to provide ministers with any legal advice, which they will get from their own legal advisors. I obviously have an obligation to be well informed about the legal components, but I'm not appointed to give them legal advice as such. So my role is therefore to ensure that ministers are provided with a clear account of any legal dispute, and I hope you'll bear that in mind and facilitate that. So in many ways, your written submissions on legal matters of issue are going to be particularly important. Now, nextly, the proceedings are regulated by the Roads Act and by the 1947 Act, and the Compulsory Purchase by Public Authorities Inquiries Procedure Scotland Rules 1997. And parties will be aware the ministers' powers to award expenses are sitting in the background also. In my view, these provisions and others do give any objector a right to a conventionally structured public local inquiry if they wish to insist on one. They don't, however, preclude the use of other forms of procedure, either as an alternative to a public inquiry or as a component of the inquiry. So it's open to parties and it's open to objectors to agree that matters in dispute could be investigated by hearing procedure or by written submissions. My procedural discretion, which I'll exercise in the interests of my investigation and of fairness, obviously remains the final word, but it's open to parties, including the objector principally, to help me fine-tune to find the most effective way of investigating their points. And finally, the provisions I've just mentioned, in my view and in the view of the DPA, do not preclude the holding of any oral session using video conferencing. So even if we do decide that we need some kind of public inquiry in the conventional format, we can still hold that using video conferencing without contravening any of the rules. And at the moment, so long as there are still government restrictions on movement and the requirement for social distancing and the other restrictions, any oral process that we decide is necessary, or I decide is necessary, will take place virtually. Okay, now, do either you, Mr. MacLeod or Ms. Maguire, do you want to make any observations on these points I've just made before we move on? Anything you'd like to flag up?
Just very briefly from my point of view, and sort of skipping ahead slightly, I suspect that a hearing is likely to be a format that would work for the objectors, and certainly from the point of view of virtual proceedings, we're very comfortable with that. Just before the meeting started, I was explaining to Ms. Maguire that I'm currently involved in a virtual public inquiry, which has run very well so far. So we're content with the DPA's system and would have no problem with the procedure being held virtually.
Good.
Okay. And on the council's part, I mean, we have made alternative proposals, obviously, in the statement of case, and we could discuss those. But if you're minded to hold a hearing, we are perfectly content to do that virtually. Again, we've been involved in that using WebEx and other formats for similar type proceedings.
Good. Great. Thank you very much indeed. So you're comfortable, particularly Mr. MacLeod, that your client's rights be adequately preserved if the form a public inquiry takes is hearing format?
We are. I think that given the nature of the issues that we've raised, they are probably best suited to a discussion rather than formal cross-examination. And having discussed it with the clients, we suspect that you'd be better informed through a discussion rather than direct cross-examination of witnesses. Right.
Okay. Good stuff. Well, these are helpful things to say, but we'll come back. We'll circle back round to that. Now, moving on to agenda item 4, I want to brutally summarise the parties' cases. Again, really thinking about what any kind of inquiry or oral process has to contain, and focusing particularly on the matters which appear at the moment to be in dispute. So, starting with the council, Ms. Maguire, I mean, how could I summarise adequately the scheme projects? I'm not even going to try and do that. But I would want to say that this is obviously a wide-ranging and complex roads project, and a couple of points have struck me, in particular from your statement of case and others. You know, this is phase 2 of a phased project, and one element of it has already been subject to a public inquiry. I think the implications of that are that in organising this, I'd like to be sure that similar procedures are followed, without anything more complicating anything, because that's what the communities affected by it will expect. But I need to be guided by you. If there are things that happened last time worked well, you know, if you could flag them up to me so that we use them.
I don't think there are too many lessons to be learned from the last occasion. On the last occasion, all of the objections were withdrawn immediately before the inquiry opened. So the inquiry basically opened and then closed, and the inquiry itself was held in the traditional format and local premises. But as I said, it was opened, closed, and the reporter then proceeded to consider the evidence that the council has submitted in the statement of reasons, statement of case, and supporting documents.
Right, well, that's helpful too. Secondly, the other thing I'd flag up to you is that the road has obviously been an element of local development planning over a long period. But in fact, I don't know very much about Perth. I know Perth's fine, of course, but I don't, you know, the kind of names for projects like the Bertha Park project and Scone North and other projects, I just don't happen to have come across them before. before. So if you'd bear in mind as you go forward that I may need some fairly basic and well-known things to those who've been involved before, I may need them explained to me. So bear that in mind, and don't be, and don't be afraid to go back to basics just to be sure that I'm fully tuned in. And the other thing about the council's case I'd like to mention is we've just worked out that the council was under the impression that the background documents, the substantial number of background documents which were attached to the statement of reasons had been passed to the DPEA, but in fact that's not the position. And I kept wondering why the case file was as shallow as it was, but in fact we haven't got those, and I think the case officer has been in touch with your office to get them passed on to.
She has been in touch, and we're arranging to do it by large document transfer via Mindcast, I understand. So we should be attending to that over the next couple of days. Yeah.
Well, that's good. And because I haven't really seen them, I'd like to go through them a bit before I make any decisions about, document timescales and that kind of thing. So there's that, and also there's quite a lot of information in there I haven't got, hence things like I haven't really seen the plans properly yet, and that sort of thing. Now, again, so far as the council's concerned, as regards Mr. MacLeod's client's objection, I think your view is that the matters at issue have substantial legal content, but that the council's view is that the council must obtain title to his client's land to be in a position to proceed with the project. Is that it in a nutshell as regards the objection?
In essence, yes. The provisions of the Section 75 agreement, in the council's opinion, do not provide the council with the certainty that it will be in possession of the land at the point at which it has to commit to the project. It is necessary for them to have control of the land at that point in time, so that, that the provisions don't provide an effective mechanism for that.
So it's an intriguing kind of grey area. There's a mixture, I think, of legal entitlement and fact, that these questions, and possibly quite technical fact. Am I right about that?
I had seen it more as an examination of how the provisions would work in practice, which I had imagined that lawyers would be able to make submissions on.
Right, right.
Perhaps factual issues is your concern that you would need some explanation about the kind of governance side of things and what the council does actually need before it can commit to a project.
I don't think I really need the nuts and bolts of that, but it's the practicalities of it. I mean, at the moment, I'm not really familiar with the actual pieces of land that are in question and their relationship to the design. So I did wonder exactly, how that worked. It was more a question of almost construction and site handover, but I just didn't know, which is why I'm asking. Maybe we should just park that just now until we've got a bit more, until the time comes to really crystallise what the dispute is. But it's convenient to say, to move on to item B. And I think, Mr. MacLeod, as I understand it, your position basically is that the inclusion of your client's land in the order is unnecessary because your clients are contractually bound to transfer it to the council when they require it. Is that a fair summary?
That's correct, ma'am, yes.
Yeah. Can I just clarify the extent, if any, to which you might intend to challenge the scheme and the order? I mean, what are you looking for excision from the order, or does your objection question necessity on a wider scale, or what are you really wanting to explore?
Yeah, our objection relates specifically to the order as it relates to my client's land. Principle of the order, my clients support. They don't have any issue with the principle of the order as such. It's really an issue about the practical implementation and the need for the order insofar as it relates to my client's land. So they are supportive of the scheme generally.
All right, right. I thought that might be the case. So it means that if you are going to have a public inquiry, there's quite a substantial element of the content of the whole order as promoted that you would wish to examine.
Did you say that I would not wish to examine?
That you would not wish to examine.
That's correct. I mean, I think the nature of our objection is fairly focused, and it's a pretty discrete point, separate to many of the wider issues that you've explained that you want to look at in terms of the order as a whole. Ours is really about the effect that the order has vis-a-vis my client's land, as opposed to the wider benefits that the order might confirm, or that the scheme might confer on the wider area, if you like.
All right, okay. It'll be very interesting to narrow that and explore it, isn't it? We'll see how we go on that. Right, good. So I have, at this early stage, got the right end of the stick for both your case and your objections. So that's good. So moving on to agenda item 5, which is to kind of visualise what I'm still going to call the public inquiry, even if it's actually a hearing to all intents and purposes. Ms Maguire, are you happy to proceed on the basis that the council has to equip me to report on the whole order?
Of course, yes.
Indeed. Of course, is a way of putting it. Now, one of the things that I personally have always found very useful in a CPO is to have a self-contained document called the scheme. It's a thing I've got a bit of an obsession with. It's something that is all-encompassing.
Would this be similar to what you requested in relation to the Lauriston Road CPO for Falkirk Council fairly recently?
Yeah.
Where we had that all-encompassing document with all the other documents sitting behind it?
It's a very useful vehicle. Certainly the documents prepared already disclose that you've already, this kind of thinking has already taken place. But yes, basically.
I'm sure my clients would have no objection to preparing that kind of document, subject to a reasonable timescale for putting it together.
Yeah, I mean, as far as timescales are concerned, I'm assuming, Ms Maguire, that one of the things your clients have asked you to do is to ask me how long I'm going to take over this. One way or the other.
Indeed, and obviously the council is keen to see matters resolved as quickly as possible so that they can make progress with the scheme. Yes,
my work programme is relatively flexible over the next few months, so I'm happy I'm almost not quite saying that the council can set its own pace, but I'd have no problems with the council deciding, telling me how quickly they want to move forward with things. But we'll circle back round again to that if we can just put that message out there.
Okay.
Right. Mr. McLeod, what sort of materials did you think you were likely to be going to produce? And ultimately, your outline statement of case is a bit short. what sort of materials are you? And I think you said that all that you're going to be needing is your client's planning permission and the Section 75 agreement. Is it as straightforward as that?
I believe it is, yes, ma'am. I mean, the outline statement of case is just that. It is an outline of the case. But as I mentioned earlier, I mean, the nature of the objection is very focused. It simply relates to the existing permission and in particular the Section 75 associated with it, what that is able to deliver for the council. And beyond that, I mean, I don't particularly intend to get into any of the wider scheme documents that the council has produced. They'll all be available for you to consider. But the issue is really very much focused on the Section 75 agreement, as I see it.
Right, good. So that really makes it. Can I ask you to think in terms, though, because purely for my benefit, because it's going to be, I don't quite know when I'm going to be able to familiarise myself with the three-dimensional aspects of this. Can you add taking some photographs of the land to your roster?
Yep.
Some illustrative material. I assume you'll have some illustrative material as part of your planning permission submissions, but if you could, give me take me there, as it were,
yeah,
without taking me there, that would be good. Okay, so I think what I'm happy to think from now on in terms of a hearing about the objection. So that's what we're going to have. Moving on to agenda item 6, timescales for the hearing. Well, what I have, because I wasn't sure what we were really dealing with, I've not made a programme for this. Can I have suggestions for you? Ms. McGuire, when would you hope a hearing would take place?
The Council's preparations are reasonably well advanced. We would be hoping that it could take place as quickly as possible. So obviously allowing for lodging of documents, which we'll do electronically anyway. Perhaps producing a hearing statement and just lining up the witnesses. We think we'd be ready for a hearing in 6 to 8 weeks maximum.
Okay. What about yourself, Mr. MacLeod? Any views on that?
Yeah, that sort of timescale I think sounds reasonable. I mean, I think I was giving some thought to timescales for lodging hearing statements, etc. And I think the norm is still 4 weeks before the hearing itself.
Yeah.
Because that then does give an opportunity for people to come in with any other written material that might assist you in making a determination in advance of the hearing. But yeah, 6 to 8 weeks probably works for us as well, I would think.
Right, so let me just... so that would take us in, that's middle of March sometime? Middle of March-ish? Do either of you have any substantial commitments in the second half of March that you should mention? No? You all right?
Can I just check with the Council's team?
Yeah, no problem.
Yeah, it's not an issue for me, but just want to check with the client. Yep, Council has confirmed that March would be fine.
Okay, so we'll think about the second half of March because we'd have to do to cut it too quickly, but I'm sure that's fine for me. Right, well, can I take that indication away and then come back with a draft programme, and I'll get the case officer to run it past you before fixing it? Is that all right?
That's fine with us.
And fine with me too.
Okay, so next thing is site visits. Now, I don't know this patch in great detail. I do know it a bit. And I've had a look at the materials that are available. I've had a look at the plan, and I've had a look at the OS map, and I've done a bit on the widely available resources online. So I'm not completely ignorant, but and of course, actually, I think there's a fly-through. The thing about fly-throughs, it's often are generated at an early stage in the project. They may not represent the final proposals. Basically, I'm open to ideas. You could fly drones all around Perth for me or something, or give me a portfolio of anything that will let me familiarise myself sufficiently to allow me to have a sense of what I'm dealing with up to and through March. Any suggestions?
I understand that the existing fly-through won't give a proper idea of the land take that's involved for the scheme.
Yeah.
We can obviously send that to you if you want it, but we think that might be limited. We had some discussions about site visits, and we do appreciate there are issues with social distancing, but I have checked with my clients and with the technical advisor, and if as a suggestion you had particular aspects of the scheme that you think a site visit, would assist you in understanding the issues, then if you could produce perhaps an itinerary of locations, it would be possible for us to facilitate site visits, provided there was social distancing and people were masked. Obviously, they would be taking place outdoors, but we could facilitate meetings where people arrive separately or by car at the places that were identified in the itinerary, and you would have the opportunity, if you wanted any technical issues explained to you, they could be explained to you on site.
Well, that's encouraging to know that that's been thought about and you're confident that that could be set up. That of itself is good to know. I don't think I want to drag you into putting together an itinerary until I'm better informed about the project. I'd like to get a bit deeper in, because it might be that I decide that there are only some places I really want and need to see. And it might even be, I suppose, that as we move towards the end of March, there may be a little more flexibility available to us. That'd be nice. So having knowing that you've thought about it and knowing that you think that actual physical site visit can safely take place, I'll just bear that in mind and maybe come back to you if I feel that there's particular locations I'd like to see. Is that all right?
That's perfectly fine. And obviously, if you require, just in relation to the locations, photographs, that could be facilitated as well. But we're prepared to be guided by you and what your requirements will be. Yeah.
Well, if you think there's something I should see, add it in. Right, good. I've already asked you, Mr. McCarthy, have some photographs to give me some insight into your client's land take and its implications. So we're going to do that. Good.
I'll do that. And I suppose just you'll be coming on to dates and so on, but would it be helpful for us to submit those informally to you in advance of any formal dates for submission of documents, etc.?
Just send a portfolio of photographs in. Well, I mean, generally speaking, the sooner you send things in, the better. So, I mean, I'm in my reading in process, so artificially delaying something if I'm reading in, it doesn't really achieve anything. But we don't want too many things flying around. I suppose you could just start your inventory early, Mr. McLeod, couldn't you? You could just do your inventory and then finalise your inventory once the deadline has been set.
Yeah, that sounds fine.
That sounds sensible, doesn't it? So if your early productions are just your first productions, and then we could extend that. I don't think that will confuse anybody. And if you send them in early, that's obviously not going to be a problem. Well, we're getting on very well with this. We've got a lot achieved here. As I said, I'm moving on to the end of item 7, which was about dates. I now know where we've got a ballpark figure, and I'll issue a draft programme for you. So that really knocks off my agenda item 8, which was a summary of my position. So that summarises my position. Does anybody have anything else that they would like to raise this morning? Any other competent business?
Not from me.
Not from me.
Ms. Maguire, good stuff. No. Always encouraging. In that case, I think I can close the meeting. Good. Right. Well, that's been painless, apart from the fact I've not been able to see Ms. Maguire. Can you tell me, was your
I'll treat you to one lap before we finish up.
Is that a real conference room behind you, or is that something else?
No, this is a stock photograph. Just by it means I don't have to tidy up behind me before coming online. Do
you know, I have to say, these the backgrounds, sometimes I've noticed they seem to cause a few problems. You know, you get fuzzy around the edges of the artificial background. And sometimes they seem to take up quite, it seemed to be quite, introduce a certain amount of vulnerability, but who knows? I don't know. I come of the generation that used to slap the black and white telly on the top to make the horizontal hole stop. You know. And one last thing, has any of you been watching the thing on the television series called Staged? Have you watched it? It's the one with David Tennant and Michael Sheen in it. Have you seen it?
Is this the one about sort of deep state fake and so on?
Karen Hamilton.
It has. The reason I commend it to you is because, of course, it can introduce the giggles, but it's a real communicating as we have been this morning, and its effects on one's psychology. I commend it to you very strongly. It's very good. It's also a great morale booster. So on the final thought, I'll thank you for your attendance and participation, and I'll issue a note of the meeting in due course. Thank you.
Many thanks. Good to see you all.
Bye.
Okay.
Cheers.
Thank you.
Bye-bye.
Bye.